So we'll move to the Liberals now. It's Mr. Fraser.
Thanks very much, Mr. Chair. Thank you both for being here today. Madame Drouin, I'd like to just go back to your opening comments with regard to what you said about September 12th. I understand that you had a conversation with the Department of Finance on September 12th, that SNC-Lavalin was still in discussions with the DPP, and you said, I therefore understood that the DPP's position on whether to invite SNC to negotiate a remediation agreement was not yet final. Did you have any reason to believe by September 17th that those discussions had concluded?
I don't have that information.
Was it your understanding from that
The only thing I can offer to this committee, and I really rely, I said also in my opening remarks that I don't know how and when the DPP informed SNC-Lavalin about the final decision. The only thing I have is the public record when SNC publicly announced, I think it was in October 10 or 12, that the remediation agreement has been turned down on them.
But by September 17th, it's possible that the discussions were continuing with the DPP and the Department of Finance.
I don't want to do any hypothesis, but I don't have the information to confirm or deny what you're saying.
Okay, fair enough. I understand that you basically are alluding to the fact that the former Attorney General was not keen on intervening or to look at this further as early as 2 days after receiving the Section 13 notice, as I understand the sequence of events. So I guess that would be as early as September 11th. So that would have, she had expressed that she was not interested, perhaps, or not keen on exploring that possibility while discussions were still ongoing between the Department of Finance and DPP. Is that accurate?
First thing, several elements in your question. On September 11th, I did receive an email from his then acting chief of staff saying that minister was not, the email was in French, let me read it please.
Yeah.
That the AG did not have the intention to intervene in the file, but that she was open to discuss it with me.
In your question, maybe I misunderstood, but I don't know. I don't think that finance has never had any conversation with the DPP. Maybe I misunderstood your question, but the DPP and finance has never discussed together. Maybe SNC had discussion with finance,
yeah.
but not the...
So according to the Department of Finance, the discussions between SNC-Lavalin and the DPP were continuing as of September 12th. And
this is the information I got.
And that email you had received on September 11th was that the take of the Attorney General at the time was not to, not keen on looking further at that matter.
That's my understanding. Yeah.
Okay. I'd
like to move now to a question in French. Were you aware of the concerns of the former Attorney General in terms of the deferred prosecution agreement, in terms of the public interest? I don't think there was concern. DPAs are tools. They're interesting tools. As you know, I applied the law in this area for financial crimes. I know it's a very interesting tool, and it is one that is available for all types of situations, and it's a tool that allows, to make corporations responsible for their actions, and we can repair the damage they did to the victims, but at the same time, we avoid re-victimizing other innocent third parties, such as employees and pensioners and shareholders and small shareholders. Nevertheless, this tool is available, and I think it is an advantage for Canada to have an additional tool for criminal proceedings, and it's always up to the director of criminal proceedings to decide whether it's a good tool or not, taking into account several factors, including the severity of the crime, the people who were involved in the crime, other investigations that an entity may be involved in. So there are several components that the DPP has to take into account. But to summarize, yes, it's a good tool, but it is up to the DPP to decide and to make the decision whether we should use it in a particular situation or not.
Had mentioned that on September 17th, that by that time she had made up her mind, and that she says, I quote, "For those who know me, I was not going to change my mind." Do you have any view or comment with regard to a usual practice of an Attorney General of not considering new information coming forward?
Well, what I think what I would like to say is that when the DPP Act were developed, it was clear for everyone that the authorities under the Act should be used on an exceptional basis, not to put in danger the independence of any prosecutors. So I think this is why we don't have any precedent at the federal level nor in Quebec, where we do have a similar regime. But that doesn't mean that it should never be used, but it should be used with a lot of careful.
Okay.
Thank you.
Thanks.
Mr. Polyev?
Mr. Wernick, on September 17th, 2018, in your presence, the Prime Minister told the Attorney General that if there was no deferred prosecution agreement, that SNC will move from Montreal. Did the Prime Minister know at the time that a financing agreement with the Caisse de dépôt made it impossible for SNC to move its headquarters before the year 2024? Yes or no?
That is not my recollection of what the Prime Minister said.
So he did not say that the SNC will move from Montreal if it does not get a deferred prosecution agreement?
That's not my recollection of what he said.
All right. How about let's turn to what you said. Hopefully, your memory is a little better on that. At the same meeting, you told the Attorney General that there would be a board meeting of SNC-Lavalin within 3 days, and they will be likely be moving to London. Who told you that SNC would likely announce a move of its headquarters to London at its September 20th, 2018 board meeting?
That is not my recollection of what I said.
Are you certain that you did not say it?
That is not my recollection of what I said. If I could explain, if you're interested in the answer, the company was operating under disclosure obligations at all times as a publicly traded company. In mid-September, the company was approaching a requirement to divulge to markets what was going on because it was 90 days after the DPP legislation had been passed. So an announcement by the company was imminent, and an announcement by the company was imminent at regular intervals through the fall and the winter because of their obligations to markets.
And when did that announcement come?
The track record of what the company said and when is on the public record. I'm not aware of that.
Okay. Also, at a December 2018 meeting, you, Ms. Raybolt says, you said, and I quote, you spoke about the company's board and the possibility of them selling out to somebody else, moving their headquarters, and job losses. Did you say that?
The options open to the company were a matter of public record in the business press.
Yes,
if I could finish, sir. If I could finish, sir.
It's just that here's the problem. Yeah. The public record was clear that they were not moving their headquarters. That was the public record. Anybody who could use Google could find shareholder disclosure showing the company had to stay in Montreal for at least another 6 years. And when you said on December 19th that the company was moving its headquarters if it didn't get a DPA, that was 2 days after the Toronto Star reported that the CEO said the company is, quote, committed to remaining headquartered in Montreal. How is it possible that you didn't know that 2 days earlier the company had publicly stated its plans to stay in Montreal when you told the Attorney General the opposite?
So you will know, sir, that it is possible for a company to retain a shell headquarters in a city and move the guts of its operations somewhere else.
But that's not what you said. You said that the headquarters would move.
That is not my recollection of what I said. I never said at any point in any conversation, this is what the company will do, because I would have no knowledge of that. I would know that there was potential risk of a number of outcomes from the company. I had communications with the company on September 18th in the afternoon, and I've just provided the committee with the notes that were taken of that meeting. And I took a call from the chair of the board on around 11 o'clock in the morning on October 18th. Those are my sole communications with the company.
But with respect, your suggestion that the headquarters would become a shell is also impossible, because the loan agreement with Case requires that the CEO, all the senior executive, all the decision-making, a large number of the board members would have to stay in Montreal. It was also public knowledge the company had just signed a 20-year lease in Montreal and announced massive and costly renovations to continue to house its HQ in Montreal. And the CEO had said publicly that he was staying in Montreal. Knowing all of that public information, why did you say precisely the opposite to the Attorney General?
That is not my recollection of what I said. And
did you say anything about moving the HQ?
If I can,
did you say anything about moving the HQ to the Attorney General? Yes or no?
Mr. Chair, I would ask you for the ability to answer questions.
Please let the witness answer the question on this.
I would welcome that.
Go ahead, Mr. Wernick.
Fact number one about the entire file is that the case is going to trial, and there is a prosecution underway. The possible outcome of that is a conviction, which would bar the company from public infrastructure contracts across the country and possibly in international markets. So the company was and is at risk.
Yes, but once again, my question, very simple. Did you or the Prime Minister ever tell the Attorney General that the headquarters would move if she did not sign a deferred prosecution agreement?
No.
Yes, you did not.
No, I did not.
Okay, thank you. And now that I have 20 seconds,
yep, you do.
Were you aware that the government was working on a provision to allow SNC-Lavalin or companies like it that are convicted to continue to bid on federal contracts? Yes or no?
These are not yes or no questions, sir. It is well known that...
To finish the answer. Go ahead. Even though the time's expired, please, Mr. Wernick, finish the answer.
So the law was brought into effect over the spring and summer of last year. It finally was brought into effect, I think, in mid-September. Like many pieces of legislation, it would require implementation regulations and protocols. And it is a matter of public record that there were extensive consultations, which are still underway by the PSPC department about implementation of the law. Those were done in the public domain, the input is there, and the Minister of Public Services and Procurement has not pronounced and issued those regulations. The purpose, as I understand it, was to make sure it wasn't a binary choice and that there would be options available to a government in terms of the consequences of a conviction, a ladder of sanctions.
Thank you very much. Mr. Assassi.
Thank you, Mr. Chair. Thank you, Ms. Drouin and Mr. Wernick, for reappearing before this committee. It's been very helpful. Now, my first question is for Madame Drouin. On pages 10 and 11 of your opening remarks, it says that I was told by a policy advisor in the Attorney General's office, quote unquote, that the Attorney General was not keen on the idea of exercising her authorities under the DPP Act. Now, to me, looking at the date, that the day this would have happened and the day you were informed of this was 2 days after the notice had been issued. Was any reason provided to you as to why the Attorney General did not wish to exercise her authority under the APP Act?
So maybe as I said to your colleague a little bit earlier, so those authorities under the DPP have never been used. So there is a risk that for any AG to use in any circumstances the authorities under the Act being perceived as political interference.
So, no, was any reason provided to you as to why they weren't?
Well, I think the reason was that the former AG didn't see any room or marge de manœuvre to use those authorities without being perceived as politically interfering in a case.
And in your opinion, was there any room to interfere?
I'm not here to provide any opinion to the committee. As I said before, the powers or authorities are under the DPP Act. It was clear when they were adopted that they should be used on an exceptional basis.
Thank
It's
you.
for the Attorney General to decide and to make a decision on that.
Now, we've heard from the clerk in his statement. I'd like to quote this passage. He says, "In dealing with the public interest, the Attorney General's decision is never final in the sense that the public interest can evolve or change." Putting on your legal hat, would you agree with that assessment?
I agree that it's the responsibility of a prosecutor. It's a continuum obligation to assess and reassess the public interest regarding a specific prosecution in light of new facts and evidence put in front of the prosecutor.
Okay. So as the factual matrix evolves, you would think that there's an opportunity to revisit. That would be the obligation, essentially.
So can you
That would
repeat
be
that?
the obligation to actually...
It's a continuum assessment, if I may say, in light of new facts or evidence put in front of the prosecutor.
Thank you. Now, another question I have for you is, would you agree that the discretion of the DPP is decidedly distinct and different from the discretion of the Attorney General?
Well, the first discretion, and that should be 99% of the case regarding decision to lay charges on specific cases belong to the DPP. And the discretion of the AG is whether to decide on an exceptional basis to overturn, change, or modify the decision of the DPP, respecting the obligation and the parameters under the DPP Act.
Thank you. Now, last time you appeared before this committee, you actually brought up the BAE decision, which has to do with discretion, and how the House of Lords, which was grappling with some of the same issues we've been grappling with, how they dealt with it. Did you ever have an opportunity to discuss the BAE decision with either the Attorney General or her staff?
I did not discuss the Corner House case with the former DPA, with the former AG. Sorry.
Thank you. Now, if I could turn to the clerk, how unusual is it for the clerk or the PM's deputy minister to speak to a minister on issues where there is friction between different and distinct ministries?
It doesn't come up very often in a cabinet of 30, 35 people. As the Secretary of Cabinet and the Prime Minister's deputy, I try to keep the flow of business through Cabinet going, and I'm very watchful for relationships among ministers and public servants. The Prime Minister doesn't always have line of sight to that. And so there are occasions where I will speak to ministers or speak to officials to try to, I guess the word might be conciliate or find a way through, because they tend to chew up time and energy, and my role is to keep the agenda moving forward. I don't do it very often. I have done it from time to time over the last 3 years. And this was a case where I could see that there was a building tension and frustration about this issue.
Thank you. Now, last time you appeared here, you testified that to the best of your knowledge, there was no improper pressure applied to the former Attorney General. In light of what we've heard from witnesses since your last appearance, would that still be your assessment?
Yes.
Thank you.
Thank you. Ms. Raitt, 5 minutes.
Thank you, Mr. Clerk. Mr. Clerk, why did Mr. Butts say this morning that he was able to get access to his own emails within days of his needing to come to this committee, but Mark Norman has had to go to court to get access to his own emails?
I'm not sure I even understand the premise of the question.
Okay, then let's try this one. Mr. Warnick, you have given incredibly conflicted testimony, and I'm going to take you through some of it. The crux of the issue, according to Mr. Butts this morning, was what and when did the Attorney General, the former Attorney General, tell the Prime Minister himself or you that she had made up her mind and she was not going to change it? Now, I asked you that question when you were here last. You didn't give an answer specifically, but we ended up settling on September 17th. Would you now say your testimony is you found out from the Attorney General, former Attorney General, that she had made up her mind on this issue by September 17th?
I accept that on September 17th, in her mind, she had made a final decision. In law, the decision was never final because she could always take into consideration public interest considerations and was able to take into account new information.
Okay. Mr. Wernick, you have provided for us your contact with SNC-Lavalin. I find it very helpful, and I want to thank you for it, but I am troubled by one thing. You went to great lengths at telling us in your last testimony about how you had only a few meetings with them, and indeed that you had several email requests for a meeting on September 18th, the meeting you took. You registered it. Then you told us about running into SNC executives at the NAC Gala and that you left right away. Indeed, the clerk contact also indicates there were further requests for more meetings until October 15th. And you took a call from the former clerk of the Privy Council, Kevin Lynch.
I believe that's the 18th.
I have October 15th here in this, whatever the date was, the date is this.
Whatever the date was.
Here's my concern. You rejected everybody else in terms of speaking about SNC-Lavalin, but you took the meeting from the former clerk of the Privy Council. And my concern is this. Section 33 of the Conflict of Interest Codes sets out exactly what a previous office holder can and cannot do. And what it says is, no former public office holder shall act in such a manner as to take improper advantage of his or her previous public office. Now, you rejected all SNC. You told us with great glee that you walked out of an important dinner that you wanted to go to because you didn't want to be seen with them, and yet you took a call from a former clerk. Do you have concerns that the former clerk breached his duties and obligations to Canada?
No.
You don't think that you took the call from Kevin Lynch because he was the former clerk of the Privy Council?
No.
Why did you take the call from Mr. Lynch?
Mr. Lynch was the chair of the board. I knew this was an active issue in October. I took the meeting with the company. They are not a pariah. It was not improper to have communications with the company. The conversation was a telephone conversation, not a meeting, and it lasted less than 10 minutes. Mr. Lynch, as the chair of the board, expressed his frustration that he did not understand why a DPA was not being considered, and he knew that the board, in its trustee relationships for the shareholders in the company, was going to have to take some tough decisions in October and November. My recollection of the conversation is he asked, isn't there anything that can be done? And I told him in the firmest, curtest possible terms, no, he would have to go through the Attorney General and the DPP through his counsel.
Wow. So not more than 2 weeks ago, when you gave your first testimony about having no contact with SNC, you said nothing about this phone call, and yet today
I was cut off, if you recall, Ms. Raitt. I was proceeding to read the chronology, and I was cut off with it incomplete and undertook to provide the chronology to the committee, which I have done.
Well, thank you for cutting me off, Clerk. But as I was going to say, I think it's incredibly pertinent, and you must have had a knowledge of it because you gave us almost a verbatim right now about what the content of that telephone call is. Can you not see how disturbing this could be for Canadians to see that former clerks who are now chairs of boards of SNC-Lavalin have easy access and immediate access into the central office of this government, into your office, when you turned down everybody else and walked out of a gala because you didn't want to see SNC anymore? Do you not see that as a problem for this country?
No.
We've exhausted the 5 minutes on that one. We will go to Mr. Rankin.
Mr. Angus go, and I'll take the next round.
Okay.
Thank you.
Thank you. Mr. Wernick, I'm looking at your statement, and I find it pretty thin gruel, given the fact that 5 former attorney generals have asked for an RCMP investigation. Former Liberal Attorney General Michael Bryant said he's never seen such, quote, brazen and reckless interference in an independent prosecution. We have had 2 cabinet ministers resign Ms. Philpott saying she had constitutional and ethical obligations in the face of political interference. You are one of the key political actors in this, Mr. Wernick, and yet I find that's missing from here is any attempt to explain what happened in that key meeting of December 19th, where we asked Ms. Wilson-Raybould on record if you threatened her, and she said she wasn't threatened once, she was threatened 3 times by you. And then she said that you wanted to find a way to talk directly to the prosecutor, which would be the interference, direct interference in the prosecution case. And she warned you that you were on dangerous ground. How come you haven't even tried to rebut her testimony?
I haven't been asked the question, Mr. Angus. I do not have independent recollection of what I said. I did not record the conversation. I did not wear a wire. I did not take contemporaneous notes. And that is not my recollection of the way the conversation flowed.
Can I put it to you, Mr. Wernick? You're asked about threatening the Attorney General. You're asked about treading on dangerous ground, and you tell our committee, well, I wasn't wearing a wire. Sorry, I don't remember. Mr. Wernick, that is not a credible answer. You are to be the clerk of the Privy Council. If you come to a meeting and you can't remember threatening the Attorney General and tell us, well, I'm sorry, I wasn't wearing a wire, I suggest, Mr. Wernick, that the brazen and reckless interference referred to by 5 former Attorney Generals refers directly to you. And if you cannot answer that question, you have no business being in that job.
So I have said at this committee before, and I would say again, I did not threaten the Attorney General.
But you don't remember. You told us you don't remember.
I am telling you now,
wire,
Mr. Angus, if
you don't remember.
If you want the answer,
Finish the answer to the question. Mr. Clerk?
I have never raised partisan considerations. I reminded her repeatedly she was the final decision maker. I did not attempt to influence her decision. I was giving her relevant context about public interest considerations. I did not suggest any consequences for her. I made no threats to the former Attorney General.
Well, so
period.
now you remember. But I will just end on this. She said she expected the Saturday Night Massacre, which is a reference to Richard Milhouse Nixon and the firing of the special prosecutor. And lo and behold, she was replaced 2 weeks later. So I think Ms. Wilson-Raybould's testimony is very credible, and I'm very sad that you get a second kick at the can and she's not being given a chance to rebut what you're saying today.
Thank you.
So, Mr. Chair, if I may.
Mr. Wernick, yes, you may respond to that.
Quickly. I note that many members at this committee have said they believe every word of the former Attorney General's testimony. Part of what she testified is she does not believe that any behavior crossed the threshold of criminal behavior. So that was her testimony.
That's the bar? It's not criminal?
That was her testimony.
Okay,
that was her testimony.
Thank you. Okay, no cross talk back and forth. Thank you very much. So that concludes. Okay, so guys, this is not now a time for debate. This is now a question of whether or not we move to a third round. I think there's sufficient time for one more round. Does everybody agree? And do we agree again that at the end of this round we give 3 minutes to each of the 3 other parties here? Perfect. So.